Friends, I just pressed the Let's Go Live button. You know what that means. We've got to wait for the stream to fire up all across the fruited plain of the internet. Before we go ahead and get started, got to make sure those tubes are connected. On the Rumble, on the YouTubes, on the locals, on the X, all across America and the world. And it looks like we're alive and well. That's tremendous. Let's go ahead and get started then, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia, and today we're talking about the Trump case. We've got a little bit of a spat going on in the New York City courtroom. Yesterday here we left off on the sanction, the $10,000 gag order violation that was assessed to Donald Trump and his defense yesterday. Of course, Trump came out, gave a statement to the AP. The judge interpreted the statement as being against the judge's clerk, and the judge has already issued an order saying that Trump is not allowed to say anything about the clerk. And so the judge hauled Trump back in. If you missed that, it was a very spicy day of court. We talked about all that yesterday. But then today, right after the break came out, the attorneys thought about it. They came back in the courtroom and they were pretty, fired up about this. They said, Judge, and they made the same points we were making here yesterday. This is his free speech. He's allowed, in my opinion, or should be allowed, to comment about the judge. And that's exactly what Trump did. And so, he was fired up about it yesterday on Truth Social. And we'll jump into the trial thread because the trial thread today started off a lot of fun, actually. They were calling Tish and her prosecutors dirty COVID-infested people and put your mask back on and get away from us, follow the guidelines, and all sorts of fun stuff. So we'll see what happened there. Then we are on part 3 of the Motherlode dismissal document cache that we've been going through, the tranche of documents that we have covered thus far. And we've already gone through the motion to dismiss. That was 2 days ago. Then the day prior to today, we covered the motion to dismiss on statutory grounds. First one was constitutional law, now is statutory law. And today we're going to finish up with the motion to dismiss for selective and vindictive prosecution. And the other one is going to be the motion to strike some of the inflammatory language out of the indictment. So we'll go through both of those. And they seem like they're a little bit shorter, like this one here, this 11-page filing, but there's actually 4 different exhibits up here. You can see we've already got them tabbed open here that we'll run through, that are supporting this, that are basically saying that Joe Biden and Jack Smith are partisan. They are vindictive. They're out there trying to target their political opponents. And so that will be a good one to unpack. And then, man, oh man, we had an insurrectionist who got away with an insurrection single-handedly. And this is Jamaal Bowman. We know he had a difficult time reading the word fire on there. And so he couldn't tell whether it was a switch or something. At least that was his original allegation. But we didn't have the video until today. Now we do. They released it since this guy took a guilty plea. But this is going to be fun to unpack because Bowman got the same deal that Sidney Powell and everybody else got, okay? Deferred adjudication, diversion. So his charges are ultimately going to be dismissed too, just like Jenna Ellis's will, just like Sidney Powell's will, just like Kenneth Chesebro and Scott Hall's will, all gone. And so it's just amazing that, insurrectionists all around this country are just getting little slaps on the wrist no matter where you look. It's kind of incredible. Amazing. So we'll go through that. Now we have the full police report. We've also got the footage that got dropped, and we'll do a little compare and contrast between Jamaal Bowman's original statement and what the video footage shows, because he said he thought it was a switch that was going to open up the door or something like that. And so we'll go through that. He ultimately got diversion, as we'll see. We'll see what the article tells us. And then the Congress, there's actually a bill in there to censure Jamaal Bowman. And so there's a lot of censorship stuff going on. I mean, it's really pretty wild. Marjorie Taylor Greene today is censuring or trying to censure Taleb. And I think somebody's trying to censure Marjorie Taylor Greene, and the list goes on and on and on. And so as you can see, my friends, we've got a lot to get to today, and I'm excited. We do have a sponsor of the show on this episode today. And so before we carry on, I want to say thank you to our friends over at Private Internet Access who can help you get a VPN. Are you using a VPN yet, my friends? I wasn't either until I realized I'm now working a lot more from public places and I don't want people creeping in on my tubes. So I decided to get private internet access. It's a VPN service that creates an encrypted tunnel for you when you browse the web. This means that people on the same Wi-Fi network can't snoop in on you and see what you're doing. When I'm doing my research, chatting, texting, sending emails, or accessing sensitive information like my bank account, I don't want people monitoring me, and the encryption from a VPN stops that. But what I also love is that a VPN allows you to change your IP address to one of over 80 countries around the world. This means you can bypass geographic restrictions on certain websites like Netflix that will often limit movies or TV shows that you can watch based on your region. This means with the VPN, you can change your region and get access to additional content you might not otherwise see. And what I like most about private internet access is that they're the world's most transparent VPN provider. With over 30 million downloads and a no logs policy, this means that they never record or store user data. All this has been verified by an audit from Deloitte, and it's also been defended in court litigation. And now, private internet access allows you to protect all of your devices with just one subscription, so you can protect your whole household in one go. Super simple. So let's get you protected when you are connected with a VPN from private internet access. Go to www.piavpn.com/Robert, and using that link, you will get 83% off and 4 months free when you sign up for a 2-year plan. Be sure to use my link for that major discount on this initial offer, and my friends will see you at piavpn.com/Robert. All right, so check out our sponsors, my friends, and thanks for supporting them. They support the work that we do here, as do you. And of course, after the show, we're going to go over for our members only after party at watchingthewatchers.locals.com. And so stick around for that. Now, before we get into the meat and potatoes on the day, I've got one special happy birthday I have to send out here. Happy birthday to Greg. This is Greg, my father. You can see him right here. It's his birthday today, and we're wishing him a very happy birthday. He's an amazing man. We're very lucky to have him in our life. And so from our family to Greg, we're saying, Greg's a part of our family, obviously. We're saying happy birthday, and we're saying it here on the show, saying shout out to Greg. Happy birthday. We love you, Greg. And so from the Watcher fam over to Greg, we love you. Happy birthday, Greg. And we'll celebrate soon. No doubt about it. Chat saying happy birthday. Yeah, that's my mom. So this is my fam. This is Greg. So that's my mama. That's my brother, Joey, if you haven't seen him, and that's Greg. And so happy birthday to Greg. We'll be celebrating soon, and it'll be fun. So happy birthday to Greg. Now we can get on with the business. All right, so let's get into it, my friends. Here's what we've got to start the day off. Donald Trump's defense promises to appeal Judge Engoran's gag order sanction. They say that Trump has free speech, and if he wants to criticize the judge's clerk, he's free to do that, especially if she's whispering in his ear, dictating how the trial is supposed to go. And so we went through the trial in total yesterday on this segment. But today, they're following up in the aftermath because the judge was there. He sanctioned Trump $10,000. He actually called Trump to the stand, put him on the stand, and asked him a bunch of questions about this, and then said, I don't believe you. I think you were talking about my court clerk. You were not talking about Cohen. Therefore, $10,000 sanction. Boom. Now, Trump later on in the day, after Alina Abba obliterated Michael Cohen on the stand, Trump just stormed out of the courtroom. He was furious, and he made a quick statement to the press and said, this is a rigged trial. And of course, we would be in concurrence with that. But then shortly thereafter, in fact, bright and early the next morning, Trump had several things to say about this. Before we jump into the trial activities, he posted several truths right back to back. And here's what he said. He said, bright and early, 7:05, he says, the radical left judge who should not be handling the fake and fully discredited case brought against me by New York State AG. It should be handled by the commercial division, but should never have been brought. Fined me $10,000 yesterday under his so-called gag order. He is a judge that found me guilty before the trial even started and long before he had the real facts. Like Michael Cohen collapsing and choking yesterday under cross-examination and completely admitting that I did nothing wrong. He committed massive perjury at a level seldom seen on the stand before. It was like watching the end of the Best Petty Mason episode, where the defendant breaks down and cries, yes, I did it, I did it, I did it. This case should be ended, says Trump. Now, But this judge and his, quote, boss, Letitia Peekaboo James, will never let that happen. He even refuses to accept our big win in the appeals court. It is a disgrace to the legal system in the state of New York. This is a rigged case. That's Trump, 7:05 in the morning. Shortly thereafter, just a couple minutes later, 7:28, he drops another one. The judge in the New York State AG case refuses to accept the overturning of his decisions by the appeals court. This is the first in the history of the state. He has gone crazy in his hatred of Trump. Also, their, quote, star witness, Cohen, just admitted his statements were all a big lie. He broke down in court. The radical left judge said he doesn't care. He's trying to protect racist AG Letitia James, who has no case, lost the appeal, but has a tyrannical and unhinged Trump-hating judge. She campaigned for AG on "I will get Trump," and her face was spasming every time she gave a lecture about Trump being illegitimate. Says, "I will get Trump," long before she knew anything even about me. This is judicial misconduct coupled with prosecutorial misconduct, and somebody from the state of New York must step in and stop this complete and total miscarriage of justice. And then, just about an hour after that one, he dropped another one. He said, the Attorney General case against me in New York State just lost its star witness. Sleazebag former attorney Michael Cohen, he was disbarred for lying and more, exclamation point, who admitted to lying in this case and clearly stated that I did nothing wrong. The unhinged judge, a highly political and fully biased Trump hater, refused to dismiss this hoax of a case and has lost all credibility. Likewise, he refuses to accept the decision of the appeals court, a first in New York. He should be ashamed of himself for having ruled against me before the trial even started and for not dismissing this rigged witch hunt now that the facts are known and that their star witness has been totally discredited, admitted to lying in court. It is a travesty of justice for all to see. Businesses are fleeing the least business-friendly state in the nation. And racist Attorney General Letitia James should focus on record-setting murder and other violent crimes, something she cares or knows nothing about. Fired up this morning. And then, about an hour after that one, we have the last one from Trump before we get to the trial. And this is, I think, important, okay? This is Trump's free speech. And I think he's exercising it, right? And we've said this before. Now, you may not really agree with some of the things that he's saying or how he's phrasing it, and that's fine. And maybe his attorneys might advocate, hey, Trump, you might want to comment down on some of these statements. Maybe they would, maybe not. But what we're talking about here is flexing maximum wingspan. You're actually puffing up like a peacock, okay? You know what? My free speech rights are being violated. I'm going to exercise them to the maximum effect possible. You're going to try to take my free speech right? Watch this. Watch this, buddy. And so we're watching where these boundaries are and what crosses the line because Chutkan gagged him and he's now been sanctioned twice on this. And at some point, okay, I think the judge, I mean, it's really reasonable that the judge might hold him in contempt or sanction him or, you know, take his ability to leave away or take his ability to get on the internet away or something like that, right? We'll see. And it'll at some point come to a head as we're about to watch. But he says this one, 9:59. Writer Hagerman, using a colorful word for her first name, of the failing New York Times wrote almost her entire fake story today about the Trump-hating judge's gag order. They love to silence me, and that is a fact. Rather than the racist Attorney General's star witness choking like a dog on the witness stand, Perry Mason, ? And admitting that I never asked him to do anything wrong, which is what Cohen did admit. He also admitted that he lied to Congress under oath. Again, brand new charges, right? And that's the thing. That's why we think Michael Cohen, and we were just reading from, you know, a very nicely crafted Twitter thread, but we still sort of, you know, don't have the actual transcript of what happened there. But that was what the Trump lawyers were so smiley about that we caught yesterday, is Cohen basically admitted that he lied again. And we thought, was that the one that he got convicted for? Like, did he admit that he lied to Congress and he's already been convicted on that one? He's already been charged and that's done? Or did he make a new admission to lying to Congress again in order to save his credibility in this trial? Because it was either you're lying then or you're lying now. And he said, well, I'm lying then. And we said, and we asked the question, well, when was that exactly? Because do those statute of limitations still apply? Like, can the U.S. Department of Justice still prosecute him for those crimes if he just lied to Congress, relatively recently? And then he came back and he's like, no. I'm lying now, not then. But I'm not lying now. It's just very confusing, right? And so they were caught. They were smiley as can be. So that means they no longer have a witness or a case. And she also failed to report that the Trump-hating judge refuses to respect or accept the appeals court decision reversing him, a first. Says Hagerman should focus her energies on corrupt prosecutors and judges whose hatred and bias is so great that they are unable to make fair and reasonable decisions. New York is crime-ridden and dying, but I will save it in 2024. It can't come too fast. So, fired up, right. Now, that is the preface for what's happening in court today. Now, Trump was not in trial today, but that's the language, okay? That's what we saw on Truth. And then we get actually into the courtroom, and reporting for us today is Klasfeld. Adam Klasfeld, he's over at Klasfeld Reports on the X platform, and I'd encourage you to give him a follow if you're interested in this type of work. He says, all right, everybody, good morning. Trump and Michael Cohen have gone. They're not in the courtroom anymore. So the courtroom thinned out for the ongoing civil fraud trial, but there are big witnesses ahead today, and we'll see who they are. But before we get even into the witnesses, we have a little bit of some fireworks at the start of the day, because we just had the gag order, we just had the $10,000 fine, we just heard from Trump. Here's what happens. Trump's attorney, Christopher Key, stands up. Your Honor, before we begin proceedings today, I'd like to call the court's attention to something that happened yesterday. You know, Your Honor, you sanctioned my client for violating a gag order, and I just want to, challenge that, Your Honor. I'd like to reopen that matter, actually, because I want to reassure the court that what my client, who he was referring to, was Michael Cohen. He was not talking about your clerk. That's why he said, I've had the chance to review the record last night, and I went over it to the AP, so I'd like to revisit this. He said that Michael Cohen was partisan, okay, not your clerk. So just so you're aware, okay, he was not talking about your clerk. I just want to be clear about that. But I want you to know this, Your Honor. However, even if he were talking about your clerk, Trump is entitled to comment on her, which was the point we made yesterday. Yeah, he can say whatever he wants about her. Why not? Okay, because if you can only, by the way, let me back up on that. He can say whatever he wants about her within the confines of the law. Okay, he can't threaten her. He can't call for attacks on her. He can't harass or intimidate her. These are all already crimes. There's already rules against that. So we don't need to come up with some new concoction rules so that the judge can protect the legitimacy of the institution against external criticism. That's the point of free speech, is to be able to criticize the institution. So if the judge says, well, you can criticize me, but you can't criticize my clerk or this courtroom, or you can't criticize anything like that, that is a limitation on Trump's speech. So Key says, Your Honor, he is entitled to comment. And in fact, this violates the First Amendment. He says Trump observes the clerk writing notes on the defense arguments. He's sitting here along with everybody else in this courtroom, and he's watching her taking notes when we're writing. She's your clerk. What is she doing, like helping you? So he's allowed to comment on that. Right? Wouldn't you want that to be the case? If there's something nefarious going on, don't you need a pressure relief valve so that you can comment on the thing that's problematic? Transparency is the best. Sunlight is the best disinfectant. Let us talk about it so that we can all see it. So, Your Honor, she's writing notes when we're doing our cross-exam or whatever. He says everybody can observe the law secretary on the bench. Okay, and we can all see her up there. There's no attempt to shield that public fact. He says, Your Honor, this is ridiculous. My client has free speech rights, and I just want you to know, if you don't lift this order, our intention is to appeal this order, and I ask for permission to photograph the empty bench if the order is not lifted. He says, I'm going to file an appeal, and so I'd like to take my camera out right now and photograph this, because I'm going to file it in my appeal. I'm going to say, here's what Donald Trump was talking about. I went back, I listened to the transcript, I talked to the reporter, whatever the attorney did. This is what he says. I think he was talking about Cohen. You say not. So in my appellate memorandum that I'm going to submit, I want a photograph of the court. If you don't lift this up. And the judge is sitting there, oh gosh, he's complaining about this. And now Keith, Trump's lawyer, he's wrapping up his speech, and guess what happens? He looks over at New York Attorney General and the government prosecutors from the civil division, and he says, you know what, Your Honor, by the way, these prosecutors are violating CDC guidelines, don't you know? They're not even wearing masks here. And yesterday, We had a big argument about this, and we had to close court down on Monday because somebody in their office got sick. And so now they're in this courtroom, and they're infecting the rest of the courtroom, and they're not even putting masks on, Your Honor, so why don't you tell them to put a mask on? And the New York Attorney General responds, and she says, that's not true. We are following CDC guidelines. In fact, here's the rule. Maybe you should look it up. Go to CDC. Says if you test negative and follow your own guidelines, right? So I'm not going to repeat this. If you test for something, you no longer have to wear a mask, okay? She shoots it back over to Keese. So they don't have their masks on anymore. Wow. Check your CDC guidelines for whatever the official rule is. Don't trust a government prosecutor, okay? Trust me. So they're fighting about masks now. Disgusting prosecutors. And so here Adam says, well, none of the lawyers on either side is wearing a mask today. Well, of course not. I mean, Trump's lawyers are healthy and they, nice, good looking people. So Adam Klasfeld says, reporting, he continues, he says, the New York Attorney General's counsel, Andrew, who's probably sitting in front of the bar while Tish is sitting in the back, he defends the gag order. He says, Your Honor, Trump can't say whatever the heck he wants, okay? The First Amendment has limits. He says, by the way, Judge Chutkan also imposed a gag order. So do you see what's happening here? So Chutkan relied on his gag order, which was very narrow. She issued a second gag order, which was much broader. And then the government in the original case can come back and say, see, a federal judge issued a gag order. So you should issue one too. And it'll probably be broader than what the original one was. So it's always the first domino, and then the rest of them just go. Chutkan also issued one, even though hers was based on yours, Engoran. So Keese continues. Trump's lawyer says, Your Honor, it's not naming anyone. Okay, it's not a post on the website. It's not a disparaging comment. He didn't say anything about anybody's name. And even assuming he was talking about your law clerk who's whispering in your ear, Judge, your Schumer's girlfriend, Keese says Trump has a legitimate basis to comment on this because it is her role in the proceeding. Like the judge can't sit there and then have like 25 clerks around him, all feeding him information, and then say, you can't comment on all of those people because I'm the judge and I'm getting independent information, and how dare you criticize my staff? What? Well, what if your staff is the problem here? So Engoran says, anybody can run for president. I have a right to protect my staff. And I don't think that's impinging on anybody's First Amendment rights to protect my staff. Which you have to buy that premise that anything that Trump said about her is a danger to her. I mean, we haven't seen any causation for that. It's a flawed premise, but the judge is making crap up. So Engoran, in my opinion, on soliciting his clerk's active input, he says, this is how I do it. I listen to her, okay? And I think it's certainly within my purview and my discretion to have an aide who can actually tell me how to do this. He says, I'm quoting George W. Bush when he said, I am the decider. And he says, by the way, I do not consider this trial political at all, just so you know, which is nice that he doesn't think that. So then apparently he issues a written order. He says he explains why he believes Trump's testimony rings hollow and untrue. He posted this, and this is a portion of it. He said, Donald Trump testified under oath that he was referring to Cohen. However, as the trier of fact, I find this testimony rings hollow and untrue. The Oxford English Dictionary defines alongside as close to the side of or next to. Witnesses do not sit alongside the judge. They sit in the witness box, separated from the judge by a low wooden barrier. And further, Donald Trump's past statements demonstrate that him referring to Michael Cohen directly by his name or by a derogatory name, but in all circumstances, he's unambiguous, making it known he's talking about Cohen. And moreover, the language that Trump used on 1025 mirrors the language he used in public statements on 10-2, where he inappropriately and unquestionably spoke about my, quote, principal law clerk, stating this rogue judge is a Trump hater, and the only one who hates Trump more is his associate up there, the person who works with him, and she's screaming into his ear. Wouldn't it be nice to be able to comment on that, because that is the person who's apparently influencing the process? If you're allowed to criticize the process, which you are, why can't you criticize the person who's barking into the ear of the judge, who's guiding the process? Seems pretty obvious. So using imprecise language as an excuse to create plausible ambiguity about whether Trump violated this order is not a defense. As a trier of fact, I find that Trump was referring to my law clerk and he intentionally violated this order. So therefore, I'm going to impose a $10,000 fine and Trump must post proof of payment to the New York Lawyers Fund for Client Protection. Signed by the judge. Now, that's all done and taken care of. He affirms it. He affirms the sanctions order. He says, I reviewed the remarks at the presser, and he argued, Trump's lawyer, he says, Your Honor, that's ridiculous. He says, Trump spoke about Cohen right after referring to the partisan sitting alongside the judge. There was a clear transition, the judge says, before that, so I think he was changing his thought. All right, so the judge is just splicing Trump's words to match what he wants to do, which is issue a sanction. So now he says, I'm done talking about this, all right? Next person's coming in. We bring in Sherry Dillon. Government prosecutors call her. Now, she's a tax lawyer who apparently worked for Trump, appeared at a widely publicized press conference. Now, she comes up, takes the stand. You promise to tell the truth? Yes, I do. Dillon rattles off her education career path. She says, I was the New York attorney. So the New York Attorney General, this guy's name is Lewis. He comes up and he starts off his questioning. Tell me what you did at the Trump organization. Dillon says, well, I did a bunch of things there. I provided tax advice. I was reviewing contracts. I was assisting with government investigations and government inquiries. And I did a bunch of stuff. I actually interacted with a host of people regularly, a lot of people. People like Jason Greenblatt, Alan Garten, Jeff McConney, Alan Weisselberg, and others. Did you ever work with Mr. Trump, the ex-president? She says, yes, I did, but not as often as some of the others. She says, I spent more time with Trump's children, people like Eric and Ivanka Trump. And that's what I do. And so can you tell me, Ms. Dillon, what a conservation easement is? Sounds like you might know what that is. Can you tell me more about it? She says, well, it's a topic that's important to understanding allegations surrounding Seven Springs. And so some background on this. So Seven Springs apparently is Eric Trump's role in it. So some property and conservation easements, blah, blah. They ask about this letter. They say, all right, so Dillon, on September 27, 2016, Schneiderman, the New York Attorney General at the time, so the government bureaucrat who was before Tisch, back in 2016, Trump's announcing he's running. The election's right around the corner in September. Schneiderman sends Dillon a letter from the Charities Bureau. They say New York has been investigating the Trump Foundation, an inquiry that ultimately led it to be fined and shuttered. All right, so this is their announcement about that. So Trump is running for office. They're trying to take him out back then. So he then shows her the letter. Here's the inquiry. Do you remember this? Yeah. What'd you do when you received this inquiry from the prior Tisch? What did you do about it? She says, well, then I went and I spoke with this guy, Jeff. I talked to Alan Weisselberg. I talked to others. Trump's lawyers jump up. Objection, Your Honor. This line of questioning, where is this going, by the way? And she's also getting very close to attorney-client privilege. She's starting to ask about these other people, and many of them, they might be lawyers. And so here, she might be crossing the line, and so they're litigating this. You know, they're saying, hey, what can she ask about? What can't she ask about? Judge says, you're overruled, Trump's defense, obviously. Sit down and shut up. She hasn't crossed the line yet. They go back to testimony. Trump's lawyer jumps up again. Your Honor, objection, relevance here. What are they talking about? Government says, well, Your Honor, we were talking about the prior witness and the insurance underwriter, talking about that there were no outstanding claims. And what we're trying to show here is that Trump knew at the highest levels of the Trump organization that this wasn't true. We're trying to say that Trump said that they were claiming that there were no outstanding investigations, but they knew that this letter from Tisch 1.0 came in. And they want to know that that was at the highest level. So in other words, Trump wasn't being honest when he said, no, we're not under investigation, because they were. So the judge says, listen, you guys, to me, this case is not just about financial statements being submitted to insurance companies, okay? He says, I don't care really about the documents or the evidence. It's about whether the defendants committed fraud, which was persistent and pervasive, right? So he's already made his decision, just so we're clear. I think it's completely relevant. He says, you know, it might not be the, quote, heart of the case, but it's in the case, so I'm letting it in. So the evidence in the line of questions are permitted, obviously. It's like, whatever. Is it bad against Trump? Bring it in. Sure, whatever. With that, the New York Attorney General Counsel then is like, perfect, thanks, Judge. They introduce the notice of violation, walks right in. Yeah, you won't even like lay foundation for it? Nah, whatever, get it in. So Dillon testifies, said, well, if, you know, I don't really remember what I did exactly when I got that letter, but what I would have done is I would have given notice to Trump and then the counsel, Jason Greenblatt. So when they got this warning from Tish 1.0, you know, this is what I probably would have done. She says, well, I did. So they have a letter. She says, well, I did. Looks like I did respond to the Charities Bureau on 10/7/2016, getting real close to the election. And so that letter gets entered into evidence. So, but you did respond. Yeah, I guess I did. Okay. Yep. Entered into evidence. No objection. Okay. It states that the Trump organization, or Trump, maybe himself, issued a directive to the foundation responding to the notice on October 3rd, the first business day after the notice. Trump issued a directive to the foundation responding to the notice on 10/3. Don't know exactly what that means. Let's see if we get more information about it after the lunch break. They go to lunch, cram down some food, feeling a little full, a little tired. Doesn't matter. We're back. Let's get to it. Dillon's testimony continues. Now, I want to show you some emails about this conservation easement project at the Trump International Golf Club. Miss Dillon? Yeah, okay, I'm looking at it. Now, I want to ask you about this email from 2012. It looks like you got this email, and it says that Mr. Trump has reviewed this layout and thought it can work for our purposes. Mr. Trump reviewed this layout and thought it can work for our purposes. Do you know what Trump is talking about, this layout? No, I can't recall what Trump is referring to here. This email is more than a decade old. Now, oh my gosh. Listen to this. So the New York Attorney General Counsel, Lou, okay, the government prosecutor, notes that Don Jr. is copied in the email and he's part of the chain, right? So she says, I have no idea what's in it. What could it be referring to? It's a decade old. I have no idea. He says, well, Don Jr.'s been copied there. You see that? She says, yeah. He says, so why don't you just speculate for us? He asks her to speculate. The defense goes, objection, because it calls for speculation, and he's literally calling, it's like he's asking her to commit an objection, like literally, like he's saying, can you please speculate? Even though the objection is objection, speculation. And so the defense says objection, judge says, sustained. He has to grant one for the defense. Unbelievable. So they keep going. She can't remember anything. Their emails are decades old. He pulls out another email. In October 16th, 2014, they say, Dillon, Cushman appraiser Brian Dilley told you that the numbers come in around 28 million for the driving range property, and that's about 1.7 to 1.75 million per lot as is, and so on. Now, talking about time and risk and all this stuff, and at some point this goes bad, right? So this attorney's having a difficult time here, this government prosecutor. Wonder why Tish isn't doing this. Maybe she should tag in, probably not. But she says, Your Honor, we have the right to treat her as a hostile witness. So this is going a little bit bad. And the government says, that's warranted because she's a former attorney for the Trump organization. Okay, so she's the lawyer. That's why we get to attorney-client privilege stuff. Now, the word hostile doesn't necessarily mean antagonistic. He says the Trump family, Cliff Robert, objects to the designation, noting that she's the former attorney, okay, not the current attorney. Engoran says that, yeah, I'm going to go with this designation. We're going to treat her as hostile. And they wrangle over a piece of evidence regarding a conservation easement being followed. And she finally says, he's trying to hit her. So like, isn't it true? And she says, well, I'm a lawyer, okay? I'm precise. I get paid to be precise. I get paid a lot to be precise. That emphasis. A lot, man. I get paid like crazy amounts, man. You won't even believe it. That's how precise I am. Dillon's remark there was in reference to being pressed about the characterization of a piece of evidence. Says, I'm not trying to quibble with you. 15-minute recess. Adam refreshes on coffee. Now, we get back into questioning. The New York Attorney General once again prompts Dillon to review the golf club evaluations of Trump's. Says, do you recall any conversations, Dillon, about the appraisals at the Trump organization? She says, no, it's been 10 years. No, I don't remember. Do you remember whether you ran any decisions with respect to Trump's National Golf Club past Eric Trump? She says, some decisions, yes, but not all decisions. Well, Ms. Dillon, I want to show you this email that you sent to Cushman, this appraiser called David, about the valuation of this other property. You sent this email October 2013. It says, I spoke to Eric and he's aware that the more supportable value at this point is about $45 million. That's the email. And so does that sentence accurately reflect one of your conversations with Eric Trump? And the defense says, objection, Your Honor. Attorney-client privilege, okay, that's between her and the client. Why is this even being discussed? Engoran says, overruled, it's relevant. Directing, please answer. Is that a fair summary? She says, I have no recollection of the conversation. I don't know if there's more of the conversation. I don't know if there's less to the conversation. She says, this is a conversation from 10 years ago. I don't know. Not a good witness for Tish. They called her in there. That was their witness. Then they turned and treated her as hostile. Then she doesn't get anything out of them. I don't remember anything. Trial adjourns for the day. Dillon will be back on the stand tomorrow. So shout out to Dillon for not buckling to these weaklings and just saying whatever they want to be said. She doesn't remember. She tells him, I don't remember. Sherry Dillon in the house, tax lawyer for Trump. So she'll be back tomorrow, and we'll be here to unpack whatever unfolds, my friends. Thank you for joining us. Thank you for sharing this channel and inviting people to come and check out what they're doing to Trump behind closed doors as we try to bring the trials to life and uncover more of their nefariousness. Thank you for subscribing as we do. All right, now, yes, and shout out to Adam Klasfeld for reporting on that. So yeah, make sure you're following Adam Klasfeld. Thank you for that one. Dan is in the house for reporting on that one. Thank you, Dana. Now, we're not done yet. We've got to jump over to a different courtroom. So that is New York City. Now we're going to be going over to Chutkan's courtroom. Donald Trump's defense files a motion to dismiss for selective and vindictive prosecution, saying that Joe Biden and the DOJ have been orchestrating an attack on their political opponent. And you can't do that. You got to prosecute according to the law and according to the principles of justice, not because you want to try to remove your opponent from the board. And this came a part of a motherlode of dismissal documents that we've talked about here. We've already gone through the motion to dismiss based on constitutional violations, 31 pages on that. We did a 34-page motion on the statutory violation, saying that the indictment just doesn't match the law under 18 and the various U.S. codes. And then today, we've got these two filings, one for the selective and vindictive prosecution, and the other is a motion to strike the inflammatory statements that Jack Smith crammed inside of the original indictment. And so let's go through each one. Now, the selective and vindictive prosecution motion also comes with a bunch of exhibits that we will unpack together as well. But this is where we'll start. 11 pages. This one's out of the Chutkan courtroom, the District of Columbia. The case, of course, United States of America versus Donald Trump. And this is President Trump's motion to dismiss for selective and vindictive prosecution. Saying, President Trump, Your Honor, Chutkan, respectfully submits this motion to dismiss the charges on the basis of both selective and vindictive prosecution. The core conduct alleged in Jack Smith, Joe Biden's indictment relating to the presentation of the alternate electors has a historical basis that dates back 1800s to the 1800s and spans at least 7 other elections. We've been doing this for a long time. There are no other prosecutions in American history related to these types of activities. The allegations in this indictment involve constitutionally authorized activities by President Trump as the commander-in-chief, as well as his speech and expressive conduct protected by the First Amendment. They say, Given this context, it is no surprise that in the months following the 2020 election, senior government officials rejected an investigation of President Trump as unfounded and potentially unconstitutional. However, biased prosecutors pursued charges despite the evidence rather than based on it, with one prosecutor violating the DOJ rules and their ethical norms by forecasting the investigation in a television interview on 60 Minutes. Even the Attorney General, Merrick Garland, felt, quote, boxed in by the onslaught. Unable to address the criticism from President Trump through lawful means while facing public pressure from a House committee investigation led by Liz Cheney, not confined by the burden of proof or the same due process standards, for example, the same congressional investigation standards that failed to preserve a huge amount of exculpatory evidence because Liz Cheney and Kinzinger, they deleted the evidence, Benny Thompson did, before the House Administration Committee got their hands on it. They say Joe Biden pressured the DOJ to pursue the nakedly political indictment in this case before the FBI had even opened an investigation. Now, less than a week before President Trump announced his candidacy for the presidency in 2024, Biden used the White House itself to tell anyone listening that he was, quote, making sure the president himself does not become the next president again. 3 days after President Trump formally announced his candidacy, special counsel Jack Smith was put in place as part of a flawed effort to insulate Joe Biden and his supporters from scrutiny of their obvious and illegal bias. He says, Trump's defense, now these actions, which are demonstrated inter alia by Biden's public statements and reports from the New York Times, as we'll see here, based on leaks from participants in the investigation, they require further inquiry and they require dismissal of the indictment. So in the entire history of this country, there's never been anything quite like this before. We have used alternate electors. We've had people challenge elections. We've had Democrats in 24 minutes, on video posts saying that they thought that their prior elections that they lost were all stolen and rigged, and they made objections on the floor of the Congress and so on. But here are the relevant facts. They say this is why this is selective and vindictive. They're targeting Trump only. In February and March of 2021, according to the Washington Post, the DOJ and the FBI rejected aggressive proposals by line prosecutors to target President Trump, including a wide-ranging efforts to trace who had financed, allegedly, the claims of a stolen election and paid for the rally-goers. They were encouraged to target the finances of Trump backers and examine slates of electors that Trump had submitted. The officials who rejected these proposals expressed concerns about First Amendment protected activities, uncomfortable analogies to other protest activities like BLM and Antifa and those, and the fact that investigating public figures demanded a high degree of confidence because even a probe that finds no crime can unfairly impugn them. However, nevertheless, following a March 2021 60 Minutes interview in which a then acting United States attorney expressed his, quote, personal belief that the evidence probably meets the elements of seditious conspiracy and those charges, the prosecutor heard from a close Justice Department ally, that the Attorney General and his deputies now felt boxed in to seditious conspiracy charges or to tough questions if they didn't bring them. And they're giving us this footnote here, which I believe is just referencing us to an article. Yes. And we'll go through those articles. I think those are attached as exhibits. Now, in November 2021, another prosecutor, who is now one of the senior special assistant special counsels who's assigned to this case, asked the FBI, that's probably Jay Barat if I had to guess, asked the FBI to issue grand jury subpoenas targeting associates of President Trump. According to people familiar with the meeting, the proposal was met with flat rejection. No. Undeterred by the FBI's determination that the subpoenas were inappropriate, the prosecutor then pitched the same idea to the Postal Inspection Services. Around this time, according to a person familiar with the exchange, an investigator working for the House committee investigating J6, quote, alerted the U.S. Attorney's Office about a few details about President Trump in connection with the House's investigation. Following this early coordination, the committee failed to preserve critical information about its activities, the interview materials, records identifying witnesses, and other intelligence and other law enforcement information as well. Amazing. So, in other words, they were forum shopping, all right? These prosecutors were trying to get people to do things. U.S. attorneys were going first to the FBI. Can you help us and go investigate? No. Then they go to the Postal Service. How about you? Can you help us investigate it? No. And so they're all kind of catching wind on it. In April 2022, the New York Times reported that as recently as late last year, New York Times, Mr. Biden confided to his inner circle that he believed that President Trump was a threat to democracy and should be prosecuted. That's according to two people familiar with the comments, another news article. Exhibit 2 is what they're showing us. The article also attributed the following to Biden, that he, quote, said, he has said privately that he wanted the Attorney General to act less like a ponderous judge and more like a prosecutor who's willing to take decisive action, go after Trump. That very same month, FBI reportedly opened an investigation into the elector scheme about 15 months after January 6th started. Why'd they wait so long? Well, the election was coming up, and Joe Biden gave the order. On November 9th, Biden was much less private about this. In fact, at a press conference, Biden stated the following, quote, we just have to demonstrate that he, Trump, will not take power if he does run. I'm making sure he, under legitimate efforts of our Constitution, does not become the next president again. Joe Biden. So on November 15th, then, Trump announced that he would run for a second term. 3 days later, Biden's DOJ appointed Jack Smith to oversee the case. In the press release appointing Mr. Smith, the Attorney General stated the appointment was necessary because of, quote, recent developments, including his announcement and the fact that he's going to run. Then on June 8th, they filed an indictment. Trump pleaded not guilty to those charges, and he argued on his Truth Social account. He said, this is massive prosecutorial misconduct that's currently taking place in America. The weaponization of law enforcement cannot be allowed to happen. Now, following Trump's not guilty plea in Florida and his public criticisms, they then filed an indictment in this case based on unprecedented facts. They say Trump here, he was doing the duty of it, the official responsibility of the leader of this nation. And he was engaged in protective and expressive conduct, all protected by our First Amendment. They say, Your Honor, there are two elements to a selective prosecution claim. The defendant must show that the challenged prosecution had a discriminatory effect and a discriminatory purpose. And they give us some rules about vindictive prosecution. They say here, the due process clause stops prosecutors from upping the ante by filing increased charges in order to retaliate against the defendant for exercising a legal right. Public statements by Biden and news reports show that there are prima facie cases of selective prosecution and vindictive prosecution here. In other words, Judge, all you got to do is just look at Biden and their own statements, and it meets the elements of both of those, both selective and vindictive prosecutions. Let's see. They say, Your Honor, deranged thug Jack Smith and his prosecutors have behaved in a discriminatory and unconstitutionally selective fashion. Judge Chutkan, with respect to the selective prosecution, the relevant theory of this case is that it is illegal to dispute the outcome of an election and work with alternate electors. That's the theory. You cannot dispute the outcome of an election or use alternate electors. They say, well, that's obviously nuts. As we made clear in our motion to dismiss, which we incorporate here, the track record of similar unprosecuted efforts goes all the way back to at least 1800, and it includes at least 7 other elections. So in light of this extensive history, it's not surprising that at least 3 Supreme Court justices have suggested that the Electoral Count Act contemplates Congress having to select among the conflicting states of electors. The Supreme Court has already said there are times when they've got to choose between the dueling slates. But what is surprising, says Trump's defense, and is likely to have an impermissibly discriminatory effect in this case and 2024, is the effort by Jack Smith's office to prosecute Trump based on his protected speech and the very same strategy. So why, if the court has said this was allowed previously, is Jack Smith relying on the opposite to bring this case? And they say, Your Honor, by the way, this prosecution is also driven by an unconstitutional discriminatory purpose. Biden has said it himself. He's publicly stated his objective is to use the criminal justice system to incapacitate President Trump, his main political rival and the leading candidate in the election. No amount of, quote, follow the evidence course correction by Attorney General Garland or Jack Smith, the special counsel, can fix this. He's already said, and we already know, that they were involved in coordination in a lot of these actions. They give us some case law about some other cases. And here, they say, unlike other cases, after prosecutors who are now part of the prosecution team were rebuffed while forum shopping the inappropriate investigation around, FBI, will you do it? No. Postal Service, will you do it? No. Biden then told his advisors that Trump should be prosecuted. Biden said that to his people. He urged the Attorney General to, quote, take decisive action. And he declared from the state dining room that he was, quote, making sure that Trump, quote, does not become the next president again. It all starts at the top. So what the government has done here is to suppress a viewpoint that it does not wish to hear. And so this is a case of selective prosecution. Now, parallel facts also support vindictive prosecution. So selective meaning you're picking one person out of everybody else inappropriately. Vindictive meaning you just have, there isn't a bunch of other people. You're just picking somebody just to go get them. So this case urged by Biden, when many prosecutors and agents appropriately saw no basis for it, they're still going for it. It's a straightforward retaliatory response to Trump's decisions as commander-in-chief. He was exercising his constitutional rights to free speech. He has a right to petition for a redress of grievances, and he has a decision to run for office. And so without question, this is obviously a high-profile prosecution with international ramifications, and it has a lot of potential motive to give rise to vindictive motive. And that motive here is manifest. We can see it. We can feel it. You can taste it. They are oozing disdain. Now, President Trump criticized the process and the results of 2020. He criticized Biden and his family during and before and after the election, including with their own misconduct and their malfeasance, in particular with regard to their Ukrainian oil and Burisma. I love this. They're dumping in all of Joe Biden's garbage with his son. All of their malfeasance, including Burisma, China, HK Limited, Russian oligarchs like Yelena Baturina, they're all there. They're trying to protect his own misconduct. Trump is now the leading candidate in the 2024 election and raises all kinds of concerns in that context as well. Likewise, Trump also criticized Jack Smith after charges were filed, and following those criticisms, Trump exercised his constitutional right to plead not guilty in Florida, and prosecutors then filed additional charges again elsewhere. Boom, just hit him again. The record is more than sufficient to justify the presumption of vindictiveness. They say, Your Honor, at the very least, even if the special counsel's office responds to this and they say, no, we're really good people, we're just following justice, he says, they're trying to articulate a defense of their decision, even though there is none. He says, we still need a hearing. We got to have a hearing to give Trump the opportunity to demonstrate that their evidence is pretextual. Here, Biden's statements from the White House, the things that he has said that have come out of his own mouth, and leaked accounts of flaws require additional fact-finding, and the court needs to hold a hearing. And so for the foregoing reasons, Trump submits that the indictment should be dismissed based on selective and vindictive prosecution. And if the court doesn't want to do that, you should hold a hearing to develop the record about the due process violations that Jack Smith and his deranged thug prosecutors have committed. So good filing, and I think that there are more exhibits here, but they're just basically the news articles, I think, is what we're going to see. So here was one, June 19, 2023, updated. FBI resisted opening up a probe into Trump's role in January 6 for more than a year. Well, yeah, they needed to time it right, you know. And they actually needed an order, it sounds like, from Joe Biden, too. Merrick Garland was there. They've done a bunch of searches. Is Trump culpable? Maybe, right? So they're submitting this article. Here's another one, Exhibit 2. Garland faces growing pressure as January 6 investigation widens. Merrick Garland was sworn in, but the deliberative approach has become frustrating. As recently as last year, Mr. Biden confided to his inner circle that he thought Trump was a threat to democracy, and there it is, should be prosecuted, to his inner circle. They say, and while the president has never communicated that directly to Garland, he has said privately that he wants Garland to act like less than a ponderous judge and more like a prosecutor. So Exhibit 3 is another one. Here, Trump, right, he made some comments. So he makes comments, he criticizes them, boom, he gets charged with crimes. Selective, vindictive. Same thing here. Crooked Joe Biden, he makes these posts, boom, he gets hit with more charges. Targeting Joe Biden, targeting the deranged thugs, DOJ and FBI, and then they all spring into action to respond to try to take him out. And so that was just one portion of his filings. But we also had this second filing from Trump, which is a motion to strike some of the language out of the indictment. And they're saying that there is inflammatory language here that is not necessary. It's just there to inflame the language. So you see it's 6 pages. It's 1023 is when it was filed. United States of America versus Donald Trump. Again, this is Trump's defense writing. They say, this indictment includes repeated references to actions of independent actors who were at the Capitol that have nothing to do with this case. The indictment does not charge Trump with responsibility for any of those actions. In fact, the indictment does not blame a January 6th speech by Trump even on those actions either. The indictment recognizes that these actions at the Capitol began before Trump had even finished speaking. And because the government has not charged Trump with responsibility for those actions, any allegations related to those actions are not relevant. They're prejudicial and they're inflammatory. And therefore, Your Honor, you should strike those sentences from the record. They say, Your Honor, the court does have the power under the rules to strike stuff. And you're allowed to do this when stuff might be prejudicial. Here's all the case law. They say courts in districts can do this. And they have done it. And in fact, here, they should do it also. They say the allegations of the activities at the Capitol on January 6 are not relevant to the charges against Trump. The indictment does not charge Trump with any J6 crimes. The New York Times reported, they said something noticeably absent with Jack Smith's indictment. He's charging Trump with multiple conspiracies, but something's missing. Any count that directly accused Trump of being responsible for violence. Stop short of charging Trump with anything like that. And also, Trump didn't get charged with seditious conspiracy or anything either. So the defense says, yeah, that's exactly correct. The government has not charged President Trump with responsibility for January 6th stuff. The allegations in the indictment relating to the actions at the Capitol are not relevant. And so they should be removed. Now, it's well settled. They say that prosecutors may not make comments designed to inflame passions or prejudices of the jury. And this applies to this indictment as well. And so in this indictment, we cannot have the jury get a bunch of stuff from extraneous allegations that aren't relevant to the actual facts at this case. And courts have before done this. In fact, we had a Chinagate issue. We had an Iran-Contra affair situation. And here, it's the same. Now, the public has a high awareness and strong views about January 6th. Allegations in the indictment relating to these actions, when Trump has not even been charged for them, is highly prejudicial and inflammatory because members of the jury could wrongfully blame President Trump for those actions. And the government didn't charge him for those actions. And a former federal prosecutor has described the indictment's discussion of the events as the worst outrage in the indictment. just saying it's waving the bloody shirt. So they say removing these allegations, the stuff that doesn't even apply, will substantially lessen the prejudice to President Trump. So therefore, Your Honor, we ask you to remove them. They say the allegations about the J6 Capitol events are not relevant to anything here. They relate to a high-profile issue. The public already knows about it. They've already got strong opinions about it. So if you include it, it's going to be prejudicial and inflammatory against Trump. And they're not relevant to the case. Therefore, you should strike, and he gives them the specific paragraphs, okay, 10D and 105 to 113 from the indictment. And this comes from Todd Blanche, John Lauro. Once again, on behalf of Donald Trump, to Judge Chutkin out of Washington, D.C. And so that, my friends, is the final batch of motions from this current onslaught of motions to dismiss, and there will certainly be more of them to attend to. Now, in all likelihood, these are not going to be granted, right? Now, Trump has to etch in and mark in each one of these issues, and depending on what the judge's order looks like, right, he might have an opportunity to file an interlocutory appeal saying that this impacts a collateral issue that is ripe for review now. But in all likelihood, they will be denied, and at the conclusion of the case, Trump will have a boatload of issues to appeal. Of course, my friends, we'll continue to cover it. That's provided that he loses this case. We'll see what happens, but I do hope you join us as we continue to unpack all of this, follow the filings, and more. Thank you for checking out robertgovea.com. We've got a daily newsletter there where we summarize all of these segments and send daily reports in after the show and the segments are over, so you never miss anything. robertgovea.com, and we'll look forward to seeing you on the next one. All right, and now we've got one final segment on the day, and this one is involving, you know who, another insurrectionist, Jamaal Bowman. And let's jump right in. Jamaal Bowman takes a guilty plea, but this guilty plea is going to be dismissed, just like all of the other ones that we saw from Big Fani Willis in the Georgia prosecution, and they were alleged insurrectionists as well. So something's happening here. A lot of insurrectionists are getting deferred prosecution agreements, and Bowman is another one. Now, I'm actually in favor of this. I think that Bowman's deal should be given to all of the other so-called insurrectionists, all the people who were sitting in solitary confinement, all the people who got 18 to 22 years for obstructing an official proceeding. Go back, revisit their plea deals and their guilty verdicts, and they can all get the same diversion deal that Jamaal Bowman got, because nobody believes that this guy in this new video footage was just trying to walk out the door. Okay, you can see him there. He pulls the fire alarm and walks right on out of it. So he gets a sweetheart deal, and we're going to talk about what exactly it looks like, because he posted a statement, and now that the video's out, we can see that they don't match up all that well. But this is what the scene looked like. Jamaal Bowman turned himself in, walked in, and this is a smart play for him, okay? It's a smoking deal. His charges are going to go away ultimately, and it's all going to just disappear. But this is what the scene looked like today.
Congressman Jamaal Bowman turning himself in moments ago. Fox News cameras capturing this exclusive video of the squad member surrendering. The lawmaker from New York is expected to plead guilty after being charged with falsely pulling the fire alarm at a congressional office building. It happened just before the House voted on a stopgap spending bill to fund government. Last month, Bowman is set to be arraigned at 9:30 a.m. Eastern time.
All right. He's a member of the squad? I didn't even realize he was a member of the squad. I thought that was just the four of the others. So anyway, so he turns himself in. Right now, he is going in there, and this was his original statement. We're going to watch the video and see if it matches up. But when this happened, remember, Congress was right in the middle of a very important vote. They were trying to continue to spend all of our money hand over fist and continue to fund the government and so on. And they were buying more time. So he said, look, I know I pulled the fire extinguisher. I know we had to evacuate a bunch of stuff. And I know this was an obstruction of an official proceeding, but it was just an accident. He said, I'm going to personally clear up any confusion surrounding today's events. Today, as I was rushing to make a vote, I came to a door that is usually open for votes, but today would not open. I am embarrassed to admit that I activated the fire alarm, mistakenly thinking it would open the door. I regret this, and I sincerely apologize for any confusion this can cause. But I want to be clear, this was not me in any way trying to delay any vote. it was the exact opposite. I was trying urgently to get to a vote, which I ultimately did, and I joined my colleagues in a bipartisan effort to keep our government open. I also met after the vote with the Sergeant-at-Arms, Capitol Police, explained what happened. My hope is that no one will take it more than it was. I'm working very hard every day for my people. Peace and love is what Jamaal says. All right. So that was his statement. Now we got the police report and the video, and this is what the video looks like, right? So that was his original statement. Here's what it was. Now there's no audio on this, but where can I move myself? Boom. Walks up, door looks locked, and just pulls it. Boom. That's it. Pulls it, walks away. Like if you thought it was a switch, wouldn't you go back to try to open it again? Here it is. So walks right up, door doesn't open, sign comes down, presses the other one, presses the fire alarm, and then goes back. So if you thought it was a switch, wouldn't you try the door again? What is that all about? And why did he just knock the two signs down right on the floor? Here he comes again. Yeah. So you can't see that, like he does have his body weight like right there, like he's trying to get out the door. And you know, maybe that's because he thought the alarm right now. Here's the other thing that the other way you could take this. Like maybe he thought the panels, just by pushing it would activate the alarm. Okay. So he pushes the one, alarm doesn't go off. He pushes the second door, alarm doesn't go off. He wants the alarm to go off. So then he hits the third thing. Doesn't go off, doesn't go off. There we go. Got it. Got it. Right? He goes, he can see the sign clearly because he knocks it off, opens it, alarm doesn't go off, alarm doesn't go off, alarm goes off. Now I'm done. Got what I wanted done. Now he knows what a fire alarm is because he used to be a high school teacher. And the last time we talked about this, we shared the actual rules, like you get suspended and kicked out of school for a second offense of pulling a fire alarm. So that's what he said. I was confused. I was trying to get to a vote. Then he like tries to initiate both of them, whatever. But this is the police report. Let's see what it says inside. And you can see here it is, the affidavit in support of the arrest warrant. He turned himself in, and we're going to look at the plea deal, right? It's all going to go away. It's a diverted offense, a deferred adjudication. So an affidavit in support of an arrest warrant. We've got Jamaal Anthony Bowman, 5'10", 240, brown, bald hair, brown eyes, bald hair, black male. Let's see. Here's what they write. The following statements are for the sole purpose of establishing probable cause and an affidavit in support of an arrest warrant, and they do not represent the totality of the facts known to your affiant. Now, your affiant, Supervisory Special Agent Joseph McAtee of the U.S. Capitol Police Threat Assessment Section, has investigated the following. On September 30th, 2023, at approximately 1200 hours, the members of the United States House of Representatives were called to a vote inside the U.S. Capitol building. At approximately 1205 hours, the United States Capitol Police were notified that the fire alarm pull station had been activated inside the Cannon House office building on the second floor rotunda at that address. The fire alarm pull station is adjacent to an exit door facing Independence Avenue on the southeast. The Cannon House office building was subsequently evacuated, and a command post was established. The U.S. Capitol Police Watch Commander's Office observed security camera footage that resulted in a radio run for a lookout for a black male, bald, in a dark suit, dark tie, with a pin under their lapel. Who could that be? Subsequent callouts were relayed by the U.S. Capitol Communications that the subject of the lookout may have exited the northwest door of the Cannon House office. A photo of the defendant was distributed to all uniformed U.S. Capitol Police officers to stop and identify. So they put out a warning for this guy. Your affiant was contacted by W2 to respond to the U.S. Capitol, to the room, to interview the defendant once they got him. Oh, that's Congressman. We know who that is. This affiant was informed by W4, who stated W1 had recognized the defendant and contacted him, resulting in the defendant responding to room H125. So your affiant arrived at this location and was conducted a non-custodial interview beginning at this hours. In attendance was W1, W3. So, code names for whoever. Your affiant advised that the defendant, Jamaal, of his position and his agency of employment. He said, hi, I'm here with the Capitol Police here, Mr. Bowman. Do you know anything about the fire alarm that just got pulled, Congressman? He says, yes. Well, what happened there, Congressman? He said, well, I was in the Cannon House office building at the second floor, attempting to exit to Independence Avenue. So the affiant, he says, I asked him, I said, you have an office in the building? And he said, yeah, I do. What office? He says, it's room 345. Okay, interesting. So can you just tell me what you saw and what happened at the door? Jamaal said, yeah, the doors stated emergency exit only, push to open. And so he pushed the door and he pulled the lever next to it, which must have been the alarm. He pulled the lever next to it. He pushed on the door, as we saw, pulled the lever next to it, which must have been the alarm. He stated the door still did not open and he went to the first floor to exit. That's a lie. Still did not open. He didn't try to open it again after he pulled the switch. He just left. So he pulled the lever, which must have been the alarm, but he didn't even try to go back to the original door. And he went to the first floor to exit. They said, well, Jamaal, did you hear alarm sounds or did you see strobing lights or anything? He says, yeah. Asked him the question, did you tell anyone about this before I talked to you? No, I didn't tell anyone. And how come you were going out that way? He says, well, I was hurried because the votes were being called. He says, I didn't want to miss the votes. I'm out there trying to get the government funded, man. You want to get paid, don't you? The defendant advised that usually when votes are called, all the doors are open. He says, I thought they were usually open, including on the second floor. He further stated that this door is a usual door that he uses. He said that he went to a Democrat meeting and a vote at the Capitol, and then the House Sergeant at Arms contacted him. He said, Jamaal, did you intend to cause the fire alarm? He said, no. He said, did you intend to cause a security concern or some other problem? He says, no. Did you intend to disrupt or obstruct a congressional proceeding or federal administrative procedure? He says, no. So he said, okay, well, I'm going to need your personal address. He said, no problem. He said, but I just got advised not to say anything else and obtained a lawyer. Okay, nice going, Jamaal. You just answered a bunch of questions. Hello. You're supposed to say this, everybody, much earlier than this, okay? Just to be perfectly clear about this. Your affiant ended the interview, so he says, oh, now you want a lawyer? Thanks. I've already been asking you a bunch of questions. This should have happened back here. Your affiant was contacted to interview him. Hi. Do you know who I am? Yes. Can you tell me what happened? No. I want a lawyer. That's rule 1. That's rule 3, actually, of our 1, 2, 3 rule. Yeah, pound your feet. I want a lawyer. So you see here, your affiant ended the interview at approximately 13:22 hours after he answered all the questions. Now, at September 30th, this officer responded to the exit door that was reportedly pushed open. And he went to observe the area. Now, he went and he observed at that time that there were 3 posted signs, 1 standing from the floor prior to the doors, and 2 posted atop the push doors of the 2 doors. So he took 3 photos of the area and he issued on the issued cell phone from the department. And of course, we can see that in the footage. It's very clear. There's a sign right here. That's the first sign that blocks you from even going in this little corridor. Then there's two right up top. And just to be clear, while we're here, he does not go back and try to open the door again. Doesn't open, hits it, should go back to try to open it again, and doesn't. So that differs from his actual statement. Now, we continue. The first sign stands from the floor, is red with printed lettering that says emergency exit only. Emergency exit only. So he didn't read that one. The second two signs posted on top of the exit doors have white printed lettering that says emergency exit only. Push until alarm sounds 3 seconds. Door will unlock in 30 seconds. So it has instructions actually. So if he would have read that, he would have known. Then the red pull fire alarm located on the wall to the left, painted red, white printed lettering. It says fire, push in, pull down, and has a white logo, says notifier by Honeywell. So this officer continues. He says, look, further investigation by me through a review of the security cameras revealed that on Saturday at 12:04 hours, Jamaal Bowman approached the exit door. He proceeded to push the right exit door push bar while grabbing the sign on it. When the right door did not open, the defendant then pushed the left door push bar, but that door did not open either. He wasn't holding it for long enough. He should have read the sign. The defendant then turned to his left, looked at the emergency fire pull station, and upon seeing it, he reached out and pulled the fire alarm down. Immediately afterwards, the defendant turned to his left, away from the exit doors. The defendant then walked away from those doors without looking back at them or trying to push them open, as he said in a lie to this officer right at the beginning. He said he tried to push his way back in. What happened to the door? It still did not open. He went to the first floor to exit, tried again, didn't work. Nope, sorry, Jamaal, busted. So your affiant reviewed the security camera footage. This footage showed 3 exit doors. At 12:04, 12:05, the defendant can be seen walking through the rotunda. So he's backing up, okay? So Bowman, he catches Bowman before he gets to this door. He wants to ask the question, did Jamaal walk by another exit? Like, is there anywhere else he could have exited? So I did review the security camera footage from the rotunda. This footage shows 3 exit doors to Independence Avenue, which apparently is where he wanted to go. At approximately 12:04, the defendant can be seen walking through the rotunda. The security footage shows flashing strobes and people in the balcony are covering their ears with their hands, damaged from this insurrection, appearing to be reacting to loud noise. We posted AOC. She posted a picture of her Apple Watch that said that her heart rate was elevated. Okay, so she was having a panic attack. I don't know if she was ducking and covering like she did the last time. So then Jamaal Bowman enters the rotunda. He goes to the first exit door and appears to push the bar. When the door does not open, he walks past one exit door to another door, which then exits Independence Avenue. So this is after. And then he pushes the door on that handle. And when that door does not open, he jogs back across the rotunda from the area when he first entered. So this dude's like panicking now. He's just like running around the door. What's over here? Over here. Open this one. Open this one. Just like spastic. So then they get more security camera footage. They go into stairwell 3 of the Cannon office building, and it shows now Jamaal Bowman, he's jogging down the staircase. Like, I'm on the run, man. Cops are after me. From the second floor to the first floor, where he then exits down the bottom of the stairs. Other security cameras then shows him walking at a normal pace out of the office, and now other people are exiting. At approximately 12:06, he passes 3 Capitol Police officers. This is a good officer. It's great. Hey, why didn't you stop and say something to the cops, man? You knew that. Did you think you set off the alarm? Well, how come you didn't tell anybody? You walked right by 3 cops, man. You didn't stop or say anything to them. So then because he didn't think he was going to get caught. Oh, man, he's busted. He's super busted. And so the defendant turns right onto New Jersey Avenue. He continues walking for 15 feet, and then he starts to jog again. He's like, oh man, I got to get out of here. Jamaal Bowman's running down Congress. Security camera footage shows the defendant continuing to jog alongside New Jersey Ave to the United States Capitol. After crossing, he jogs past 2 more Capitol police officers. He's like, looking like this, running, like he's like Jason Bourne or something, trying to escape his captors. And he goes at a kiosk, and then he begins crossing into Southwest Drive in the Southeast. Then at 12:08, so now several minutes have gone by, he enters the Capitol. While showing his credentials, he walks past 2 Capitol police officers again who are posted inside the entrance, staffing the metal detectors, presses the elevator button, waits 10 seconds for the elevator door to open. And during the 10 seconds that he was waiting for the elevator, he's standing within feet of one of the Capitol police officers and doesn't say anything to him and just enters the elevator. He thinks he's free. Due to the defendant's actions, the office building was evacuated for 1.5 hours. When he pulled the emergency fire alarm located here, there was no fire at that location. Therefore, based on the evidence, this affiant has probable cause to believe that he knowingly gave a false fire alarm. That's it, in violation of local DC Code 2213-19A. Oh, come on. So he clearly was trying to get away with it. From the video, it looks like he was trying to set off the alarm. And he didn't talk to any cops about this. He didn't say anything about it until he got busted. Then he starts sitting down, tells them everything that they need, and then he says, I want a lawyer now. My gosh, we have some of the dumbest people in Congress you've ever seen. So that's Jamaal Bowman's arrest, and it's just outstanding. So obviously he's clearly guilty. Now, what's interesting about this is that he got a diversion deal. And boy, this is the same deal that we saw Jenna, Ellis, Sidney Powell, Kenneth, Chesebro, and Scott Hall get in Georgia. And just to be clear, right, we're seeing a lot of these deals. But here is what this outcome was. Bowman struck a deal in which he pleaded guilty, right, to 1 single misdemeanor offense. Now, there's a big difference between a guilty plea. You could have a guilty plea agreement. You could have a guilty plea deal. You could have a guilty plea deal, which is just a verbal agreement between you and the prosecutor. Do we have a deal? Yeah, we do. Perfect. Let's take the guilty plea deal and put it into an agreement. Let's formalize it, write it down. Great. We need to go to a change of plea proceeding so that we can enter in our plea agreement. Then you go to the change of plea. And so you can execute a guilty plea, but you can suspend that and defer the entry of that pending the outcome of some probation, which is what happened here. So according to the terms of the deal read aloud in court, Bowman's sentencing will be deferred for 3 months. And during that time, Bowman will be on probation, a $1,000 fine, and he's got to write an apology letter to the Capitol Police. If he fulfills these terms, the prosecutors will drop the charge at the sentencing hearing, and it will go away completely. It's literally the same thing that's happening for Sidney, for Jenna, and for all of those 4. It's the exact same thing. Now, obviously, this is outrageous because this guy should have been charged with the same things that the J6ers were charged with. Obstructing an official proceeding. It was an hour and a half. It was a loud, startling, violent attack that caused AOC to have heart palpitations or something. And so there should be full repercussion for this because they said that obstruction of an official proceeding was a great attack on American democracy, but not so much apparently when it's their side. Now, the reason I keep bringing up the other case, right, the Sidney Powell and the Georgia RICO case, is just to make it hurt for the left to show what a good deal those were. Those were such good deals that they're just going to go away because they keep saying, oh, they got guilty convictions and all this. Absolutely wrong. All of those cases are just like this. Now, a little bit longer, a little bit serious, a little more serious fine, a little bit more serious term of probation, but it's the same exact mechanics. And so Jamaal Bowman here, of course, is getting a slap on the wrist. This thing's a joke. We all clearly saw on camera what he did. And to be quite frank about this, the Capitol Police know it too. what we like about this is the Capitol Police know it, and we know that the Capitol Police know it, and how we know they know it is because they really spent some time digging into this. He didn't talk to any cops at all. He was running down the street away from culpability. He was trying to escape responsibility for doing it, and they caught him. They busted him. And so I think that speaks to the truth of what happened here. But we now know that Congress is trying to censure him, and this was a resolution that came out from a House representative member called Lisa McClain, no relation to John McClain, the hero of Nakatomi Plaza. But here is what she has submitted here, a resolution to censure Jamaal Bowman. Submitted this one, and she says she's going to bring this one aboard. Says, whereas on September 30th, the House of Representatives was considering legislation to avoid a session of appropriations and the shutdown of the government, and Jamaal Bowman, the rep from New York, pulled a fire alarm to obstruct the proceedings of the House. The District of Columbia makes it a crime, a misdemeanor, punishable by 6 months in jail when you do that. But also, and more importantly, the United States Code forbids anyone from corruptly, by threats of force, obstructing or impeding any proceeding before Congress. This is what he should be charged with by the DOJ, just like the J6ers were. They say here the actions of Bowman forced the evacuation of the Cannon House office building and disrupted the Congress while the floor vote was already underway. Here, the interruption of the official proceedings by pulling a fire alarm was a theatrical attempt to cause panic, therefore endangering the safety and the well-being of members of the House and members of the public on the Capitol grounds. And so, therefore, be it resolved that the House of Representatives censures Jamaal Bowman for violating the district code, for knowingly causing a false alarm and obstructing official proceedings in the House, saying that Bowman must present himself in the well of the House for pronouncement of the censure, and that he will be censured, and all of this will be read into the law by Congress. And justice must be balanced, my friends. It's only fair. If he's going to insurrect America, well, insurrection-type penalties must be brought his way. And so, of course, we'll see where this goes, if it goes anywhere. I'm not sure that it actually will, but we'll cover more of Congress's idiocy in time, my friends. I hope you join us as we do. Thank you for subscribing. Thank you for hitting that like button. Thank you for checking out our website at robertgovea.com, and we'll be looking forward to seeing you on the next one. All right, my friends. Well, that is going to be it for us on the day. We covered some good stuff today. Insurrection, we got some Motherlode document completion. That's taken care of. We've also got now the promise of the appeal from Trump's defense, saying that this gag order is a violation of his free speech. And I couldn't agree more. But now, my friends, it is time to hear from you and to see what you have to say about all of this and more. We're going to go over to our members-only community here after the show's over for our members-only after party. And so if you're a YouTube member, come and join us over at on the Telegram. If you're a YouTube member, join us on Telegram. But if you want to join our community, watchingthewatchers.locals.com is the place to do it. But now, my friends, let's see what you have to say about it. Thank you for these very generous donos in the house on this lovely Thursday. We got Custer Survivors is a new member over on YouTube. And so, YouTube friends, make sure you grab that Telegram link. You can navigate to the community tab section on YouTube, and we will see you in the after party. We got Dolphin Fan is the man, bringing in new members. Thank you, Dolphin. Look who's coming in. We got Kevin H, Spitfires in the house, Frank B, we got Kat J, Matt O, all in the house, courtesy of Dolphin Fan is the man. Thank you, Dolphin. Love the generosity, my friend. We got Laura Smith is here as a member. Welcome aboard, Laura. And we really we try to deliver for our members. We do Saturday shows, we do morning streams, and so we've already had a stream before this one this morning, and it was a lot of fun. And so we got Knox Bierman's in the house. What's up? Says, happy birthday, Greg. Early out today so I can catch the whole show. Happy Thursday, all. Good to see you, Knox. Hey, we're glad you got to make it for the whole day. And shout out to Greg. Happy birthday to Greg, and thanks for saying that, Knox. Good to see you. Katrin Taylor, welcome as a supporter. Woo, we're getting some new supporters today. Loving it. Good to see you, Katrin. Welcome aboard. We've got this one from Crimadella. Crimadella's here. Crimadella says Mark Meadows joined Trump's cabinet for the purpose of wearing a wire to spy on Trump. This has been confirmed. That is from Crimadella. I have not confirmed that. I saw a lot of that was rumoring around, unless that's been confirmed since the show started. I'm not doubting you, Crimadella. I just want to be careful about that because I did look some of that up. And I don't know that it's confirmed exactly yet. It's concerning. What we've seen is concerning. There's no doubt about that. And so, what's up, Geegum Geegum's in the house? Says, here's our motion for dismissal. We've got a new meme. Here's what we got. Denied. Oh, yeah, that was the one from yesterday. And what does it say about him? And everybody freaks, man. That's from yesterday. So that's what Trump did yesterday when he, thank you, Geegum, I love that. And unfortunately, I think we're probably going to have to use that one a lot because we're probably going to have some denial motions. And that's what Trump did. He stood up and he freaked out everybody in his community, in his courtroom, his Secret Service people. Where the heck is my folder where I save all of our memes? There it is. All right, denied. That's the denied meme. Boom, got it. All right, thank you, Jigan. Beautiful meme. We got Kevlar's here. What's up, Kevlar? Says, can they bring Letitia James to the witness stand? I'd like to see that. No, I mean, not really. Not without any real reason. Unless they were alleging some impropriety or something. Unless she did something. I mean, she made that joke from the back, like, objection. You know, but there's no reason to bring her to the stand. Unless there was, like, maybe like some malicious prosecution type of motion and you want her testimony in that or something, but nothing now that would justify that. What's up, Kevlar? We got Catherine Rex. Hey, what's up, Catherine? Bringing in 5 membos. Woo. We got Brandon R, Garrett P, we got Janine S, we got Mitch M, and Jonathan C. What's up, Jonathan C? In the house. Coming in, joining us. And thank you, Catherine Rex, for bringing in 5 new membos in the house and says, Rob, you the man. Thank you for all you do for us. Well, Catherine, thank you for what you do for us, bringing in new membos and joining us and having a lot of fun in our chat with us. We've got this one from Yohei Plumbing over on YouTube. Says, why doesn't Trump's attorneys send copies of Congress's oversight committee? His appeals and the judge's denials being it's absolutely political, especially New York and Georgia's. Just asking, Mr. Govea. Good to see you, Yohei, and thank you for being here. And thanks for the dono. Says, why doesn't he send copies? Well, so I think that there probably are. I mean, there probably are. I don't know that they're communicating with oversight. Like, I don't know that Trump's attorneys are communicating with oversight, but I would guess that they're kind of overlapping in some way. Maybe Trump's team is communicating to them in some way. I'm sure they're following it. But I don't know what the oversight committee could really do other than, you know, I mean, they are investigating the DOJ. They're sending letters over there. I know Chuck Grassley just sent letters over there. So Congress regularly sends letters to, you know, the FBI and the DOJ. But from there, I'm not sure what else they're going to do. But it's good to see you, Yohei. Thank you for the nice question. And this one from John McGarvey's here says, how can he get a deferred action for first offenders when he has already been arrested for protesting at the Capitol? And I want the mugshot. Yeah, I don't know if he took a mugshot. That's a really good question, John. And I don't know what the specifics were there in Washington. Does Jamaal Bowman have a prior offense? Do you have to have no prior offense? In Georgia, you had to have no prior record. Is that the same situation in Washington, or do they get a little bit more discretion? Either way, we should definitely have a mugshot. Pinochet, what's up? Pinochet's Helicopter Tours says, wow, New York, come get your liar caucus rep. Hamas caucus rep, please. So I didn't even know that guy was a part of the squad. Learned something new today. Cindy Banks says, that judge is not that smart. That's why the clerk is whispering in his ear. He is Joe Biden in robes. He's just not having a good time. He's not all that competent, not all that capable. Yeah. What's up, Cindy? Thank you for that. Yohei says, Marjorie Taylor Greene filed to censor Taleb, so that Democrats filed to censor Marjorie Taylor Greene today. So we covered the Marjorie one this morning on our members only stream. We came across that. She had just dropped it this morning and we were chatting about that. And then, yeah, they censured her today. and it's just going to be a total free-for-all. Round and around we go. Hey, it's G-Gum. Look at this one. Too funny. So G-Gum says, happy birthday to Greg. Look at this one. And man, that's probably what it's going to look like here soon when we have our birthday party. Yeah, sometimes Greg has spaghetti in the hair. You know, it's just, we get hungry over it. When Mama Govea makes the meatballs, we get very hungry. Thank you, G-Gum. I love that. And I'm sure he's going to see that. So he's going to love that too. So thank you for saying that. Super, super funny. All right, and so love it. We got the whole family now. We got the whole family meatballed out. And we got MAGA Hat Stays is here. Says, okay, says not confirmed, has been denied. Besides, Trump believes that he won the election. So what's there to flip on? Yeah, that's kind of my take on it. It's like, what is Mark Meadows going to do? I'm not as concerned as I think a lot of people are about this flipping stuff. Like, I know a lot of people are freaked out about it. I am not that freaked out about it. Like, Mark Meadows wrote a whole book about how he thought the election was rigged and all this stuff. Like, what's he going to do? You know, like Cassidy Hutchinson was somebody who flipped, but a lot of these people are not in that same position. A lot of these people were like hard workers. They've got a record of believing that it was true. And so, like, I don't think, you know, I'm hard pressed to believe that they're going to turn around and say, Trump ordered me to do illegal things and I knowingly went and did illegal things. Like, I don't think that they're going to say that. So what is Meadows really going to give them? I don't know. I mean, if he wore a wire or something like that, that would be a whole different story. I have a hard time believing that he wore a wire, that they would put a wire on him, generally speaking. But I could be wrong. I mean, that would be incredible. That would be incredible if our FBI had a wire on the chief of staff of the president. Like, that would be unbelievable, which it could be, you know, because we have an unbelievable FBI. But I'm always waiting on those. I'm always skeptical on those. Like, let's just wait and see. Because I also, my friends, I think it's very important to not throw people aside like that, right? Like Sidney, Mark Meadows, Jenna Ellis, you know, Scott Hall, Kenneth Chesebro, all of these people, if they are just thrown into the dumpster, I think that's going to make them more inclined to, you know, not be an ally in this battle. And that makes me nervous. So I want to be skeptical. I want to make sure we give everybody a fair shake on it. And, but I did see the reporting, and I did see the reporting, and I saw it like, oh man, this is kind of a big deal. So we'll see. Yeah, we'll see. Now, thank you for those very generous donos, everybody. Very much appreciated. Your support, your membership keeps our work here possible, and we're grateful for it. So now let's say what's up to our friends on the X platform and see who is joining us over there. Do we have anybody in the house? 8 viewers. Oh my goodness, that's almost 10. Hey, we got a happy birthday to Greg here. Yeah, and I saw this one. So happy birthday to Greg from Chicago Jan. What's up, Chicago Jan? We got Cremadella. Yeah, so what's up, Cremadella? That's the one from Ryan Fournier. I did see that one. Goofy for Jesus is here. Says, I tap my heels together and say, there's no place like 24. There's no place like 24. There's no place like 24. From Goofy for Jesus. Couple comments from Goofy for Jesus saying, happy birthday, Greg. Troll says, are you on Rumble yet? Absolutely. And Chappaquiddick Drinker says, Rob Bowman was a high school principal before Congress. Now we should know he doesn't understand how fire alarms work. I know. He knows. He knows how they work. He knows exactly what he was doing. All right, my friend. So that is it for us on the day. We are going to leave it right there. We are going over to watchingthewatchers.locals.com for our members only after party, and we would love to see you over there. And hey, what's up? Catherine Rex gets a Bodie. This is from Jigam Gigam. Catherine Rex gets a Bodie. Catherine Rex, you rock. That's from Jigam over on Locals. And it's good to see you, Catherine Rex and Jigam and Bodie, all in the house. But my friends, all right, that is it for us. We are going over to watchingthewatchers.locals.com to hang out for a little bit longer. We'd love to see you there. But if not, well, we will be back here tomorrow to do it all again. Well, what is tomorrow? Tomorrow's Friday. So we've got Trump will be in trial. We'll see if there's any more documents. There'll be a lot to attend to. And that's what we'll have in session. So I think, let's see, is there one more thing? Anna Squires became a supporter. What's up, Anna Squires? Also became a supporter. Just missed that one. And this is the GIF. That's the Bodie gift. Gifted membos. Catherine Rex, you rock. 5 gifted membos. Woo! All right, thank you. That's so awesome how Jigam can fix those so quickly. Pretty amazing. Okay, thank you, Jigam. Thank you, Catherine. Thank you, Bodie. Thank you, V, for the GIF. I skip over the GIFs. They don't follow in sequence, so I have to click them separately. But that, my friends, is it for us on the day. And we did cover some good ground. We're not done yet on the week. And so we will be back here tomorrow to get into it all again. And we hope to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.